Good morning, everybody, and welcome back to the Law and Crime Network. I'm your host, Jesse Weber, and thanks for joining us again today. We have some big updates in the cases that we have been covering in case you missed it. We have verdicts in the Xavier Dobson and Todd Kendhammer case. The Todd Kendhammer case, we had a verdict late last night. Just going to tell you what happened. So as you know, this is the case about Todd Kendhammer, who was charged with fatally beating his wife of 25 years while she fought for her life. And then it was claimed that he tried to conceal her cause of death by staging a freak car accident. Well, a jury of 10 women, 2 men, deliberated for about 9 hours last night. And at the end of the 9-day trial, they have found Todd Kendhammer guilty of first-degree intentional homicide. His family, his supporters, they wept, they gasped when this verdict was laid down. His family actually shouted at reporters outside the courtroom. Circuit judge in this case revoked Kendhammer's $250,000 bond and set sentencing for March 9th. We're going to talk all about this verdict and whether or not you're surprised or not. This was, many people thought that this might be a reasonable doubt. Maybe not. He would have been found not guilty, maybe a mistrial. We'll talk about that in a moment. But as I said, we also had an update out of Knoxville, Tennessee in the Xavier Dobson murder case. Guilty verdicts have been handed down against all 3 defendants. Now, if you recall, Xavier Dobson, this 15-year-old high school football player from Tennessee, was shot and killed when he shielded his friends from gunfire. These shots were alleged to have been, at the time, fired by Christopher Jerome Bassett, Richard Gregory Williams III, and Kipling Colbert Jr. And as it was laid down yesterday, Mr. Bassett, who's 22 years old, was found guilty of first-degree murder, several counts of first- and second-degree murder, and several counts related to the employing and possessing a firearm. Mr. Colbert and Mr. Williams were found guilty of facilitation of first-degree murder, several counts of facilitation of attempted first- and second-degree murder, and charges of facilitation of employing a firearm. Again, this was a shooting. This was done in a public place. One shot killed Mr. Dobson, and that is why you see the differing guilty verdicts in terms of murder, facilitation to commit murder, and first- and second-degree murder, and also employing a firearm. Well, all 3 men were found guilty. There's another case that I want to preview for you as well that we're going to be covering next week. It's a case out of Iowa. This is the case of Larry Whaley. He's 60 years old, and he's been charged with first-degree murder in the death of 19-year-old Samantha Teeter by shooting her through the door of his apartment. Whaley has actually written letters to the judge in this case, Judge Christopher C. Foy, claiming he wouldn't receive a fair trial, that evidence is being withheld, that his attorneys are lying to him, that there's witness tampering, that his cell phone and car had been stolen, and that his rights had been violated. Very strange case, but he seems at this point to be claiming self-defense and that the killing was not intentional. It's interesting to see a defendant really taking such a proactive stance in this case, and his communications will definitely come into play. But it also should be noted that at one point it was questioned whether Mr. Whaley was competent to stand trial after he committed this shooting. Officers said that he was talking to himself and that he was saying they were trying to break in, Well, he has been deemed competent to stand trial. We expect opening arguments either Monday or Tuesday of next week, depending upon jury selection, so you're not going to want to miss that. But I do want to talk a little bit right now about the Todd Kendhammer verdict, because this case was really, really different. We were kind of split about whether or not the jury would find him guilty, and they found him guilty after 9 hours of deliberation. So let's break it down a little bit. Joining me now is criminal defense attorney Jayne Weintraub. Jayne, great to have you back here on the program.
Thanks, Jesse. Good morning.
Good morning. So I have to ask, starting off, are you surprised by this verdict?
Well, not really, with 10 women on the jury. I mean, that's a really
You think
good
that's a
call.
factor? You think that's a factor?
Oh, I think it was a tremendous factor. You know, people take their common sense back into the jury room. They take the jury instructions and their common sense. And in this case, the prosecutors just pinned and pinned and pinned on, if he's lying, he's guilty of murder. They didn't go through the elements of the crime and prove that beyond a reasonable doubt, in my opinion. I don't think they made that their focus because I don't think they had it. The defense harped on the fact and attacked the evidence that the state had. They called expert witnesses to show that the accident happened the way it was supposed to have happened, the way he said. The fact that he lied on the scene doesn't make a man guilty of murder. This is the United States. It was circumstantial evidence as far as the state was concerned, which can be given the same weight as direct evidence. It's up to the jury. That's where 10 women come into play when you're talking about a wife that dies in a freak accident.
But what do you think was the real key for the prosecution here that really the jury couldn't get it past? I have to say I'm surprised that not at least one juror thought that there might be reasonable doubt here that it was possible that it was a car accident, because as it came, as the defense and their experts showed, it felt like it was at least possible that this might have been a car accident. But was it the stories? Was it the fact that he had 3 versions of where he was actually going that morning with Barbara? Was that really what did it for him?
Yeah, I think 10 women on a jury don't like a husband that's lying when the wife dies. I think the medical examiner who works for the state, he's not looking for a real cause of death. He's looking to prove the state's theory. That's what medical examiners do. This is not a TV show. This is real life. The medical examiner comes to the scene, and they also had a pipe that was similar that was found nearby, meaning that it was contrived and that was the real pipe and that the pipe didn't kill Barbara. So I think those 2 factors, the jurors and the medical examiner, I think is what controlled this case. I think the lying is what controlled this case, not the evidence. They don't have to prove, the state does not have to prove a motive. Why would he want to kill her? But of course, that's something that everybody wants to know. Why would he? And in this case, the defense really addressed that by calling his kids. And his kids testified, look, nobody has a perfect marriage, except me, of course, but if my husband's watching. But the truth is that one of the things that the prosecutor mentioned in closing argument is he even lied about his marriage. Painting this, Ozzie and Harriet, he didn't use those words, I am, Ozzie and Harriet like life. Well, you know what? That's not real. Reality is you love somebody, you live with somebody, and you compromise. And either you're happy and you want to stay married or not. What does that have to do with whether or not he committed this murder when there was no motive that was used? In other words, was he going to inherit money from her? If there was a divorce, was there a prenup? So the state never tied that in. And so what if the guy was going to have an affair? That doesn't make him guilty of murder. It just makes him a lousy guy.
Right. I thought it was interesting when they said we can't get into his head. You see people who get divorced and you thought they were happy. You see people cheat, you thought they were happy. You see people who are sick and you saw them the week before, they looked healthy. So you have no really idea about what goes on between 2 people, and I'm sure that even you present a different image to family, to friends, to children even, than what really might be going on. I thought that really what it was interesting was, where was he going that day? Why was she going to be late to work the first time ever, and it happened to be that day, and she didn't call that she was going to be late? I thought the fact that she didn't call her mother, even though Todd had called her mother multiple times, I think even 300 times in the past year, which is common, but still it kind of added to the fact that she didn't call her mother that day, but Todd did. And the fact that her purse was in the back seat, so she couldn't make that phone call. And he said he was going to one person's house, Jerry Logan, but he had actually passed that road when he was driving the car initially. I think that's really where it might have been too much for the jury.
But there was no toxicology that was brought out. I mean, it wasn't like she was drugged. I mean, the things that you're talking about might fit for me as a juror if she was drugged and, the implication is that she couldn't get to her phone. Why couldn't she reach in the backseat of the, I mean, not that I would ever do that while I was driving, but why couldn't she just reach in the backseat and get her purse and get the phone? That's ridiculous. Of course she could. Those are the kinds of things that the prosecutor builds on that I don't understand. He's not building on evidence of proving how the murder happened. Was it an intentional killing to begin with? Was it murder? I'm also surprised that it came back as a first degree, because where is the intent by him? Because the mother-in-law's not called? Are you kidding me? That to me is not, proof of any criminal activity afoot.
Well, see, I thought it was interesting from the defense. So if we move over to the defense's closing arguments, they kept saying to them about the state, you want to say that he planned this out, or do you want to say that he acted out of rage and it was a sudden killing? They keep changing their story to fit what works best. I thought that was an effective part of the defense's closing. I thought the defense actually gave a pretty strong closing argument. Unfortunately for Mr. Kendhammer, it wasn't enough to convince them. Do you think that the defense should have done something more? Was there something that was lacking in their case? And I know we never want to criticize after the fact, but I'm just curious from your perspective, was there something that maybe they should have harped on a little bit more that they failed to do?
I don't think so, and I wouldn't hesitate to make a suggestion or a criticism, because the bottom line is that's what we're doing. We're doing an epilogue, and we're doing a Monday morning quarterback. The problem is it's not really doing it on the closing or the defense. It's really what was going on in the jury room, because I will bet you dollars to donuts that those women were talking about the relationship, her purse. Why was she late to work? I mean, I hate to tell you how often I'm late, even in a jury trial, for a myriad of reasons. Not intentionally. It's just things happen in life. That doesn't mean that criminal activity is afoot. Sometimes you have a bad morning. Sometimes maybe they were having a fight. So what? That doesn't mean that he went to kidnap her and kill her, because the focus is distracted. Where's the evidence of the intent? Where's the phone records by the state? Where? Where's his computer records? Where? Where is any planning going on? Where? There was none. And so his biggest problem were all his inconsistent statements, in my opinion. That's not the defense's fault. That's the defendant's fault.
And two questions for you. First, the 9 hours that they were deliberating, that shows, in your opinion, that they were struggling with this a bit, or is that hard to say?
No, I think there is somebody that wasn't ready to vote guilty. I think the first thing that they do is they elect a foreman, they pass it around, and then they usually take an initial vote, and they will see where they are. If it's 1, 2, however many people are not ready to make a unanimous vote. I think it was a minimal amount, but I think somebody had a problem with finding him guilty of first-degree murder. And I don't think it was a matter of compromise, because then there would have been a compromise after 4 or 5 hours. And these jurors wanted to work in the night because, like Florida, Wisconsin sequesters first-degree murder juries, and they don't let them go out to be exposed to any newspaper, radio, or family members that have been watching it.
Do you think it was a mistake for him to take the stand?
That's something that's just so personal and so hard. What I tell clients, Jesse, is this is a personal decision. I am going to give you your legal options. I'm your legal mouthpiece. This is my advice. It is always hard if you have, or if you feel that it's necessary to put someone on the witness stand. It depends what kind of witness he's going to be, what kind of witness, what kind of mock cross-examination you've done, what other people have brought out. It's a tough call.
Even when he shows emotion, you're seeing him right now, we're showing on the other side of our screen that he was emotional on that stand, and it wasn't enough. And we had covered the Adam Matos case out of Florida, and that guy took the stand, and he was an emotionless robot. The jury didn't buy that. They didn't believe his story, and obviously they didn't believe Todd Kendhammer here.
10 women are looking at this guy crying and saying he's full of it. That's what happens.
Well, I'll tell you what, I do want to play now for our viewers who didn't get a chance to see it, the actual verdict in this case when it was handed down, when Todd Kendhammer was found guilty of intentional first-degree murder. I want to play that for you. You can hear the gasps in the courtroom, you can hear the reactions, and just you can kind of see how surprised both Mr. Kendhammer and his defense team were. Take a look.
be seated. The jury exhibits yet, right? Yeah. The two that day, yeah. Give me those two, I'll put them on the record. Right, we'll go back on the record. State of Wisconsin versus Todd Kendhammer, 16 CF 909. Been advised that there is a verdict at this point. Put a few things on the record before we continue. We had two jury questions, if you want to call it that. 540, could we receive photos 19 through 41? Exhibits, we sent those in. 541 was, can we view photo exhibits from Dr. McCubben's autopsy? And we sent in basically all the photographs received during her testimony. Not necessarily every exhibit, but between exhibit 6 through 74 for the state and 201 through 204 for the defense. Exhibit 542 is when I released the 13th juror after the bailiff conferred with counsel. There was no objection. And Exhibit 543 is a photograph and email that the courthouse remained open up through this point, so that's part of the record. So any objection to those exhibits, Mr. Grinke?
No.
Mr. Hurley?
No.
All right. Right, in a few minutes I'm going to ask the jury to come in. I expect absolutely no comments in any way, shape, or form from any member of this courtroom at this time. Anyone that does so will be disrespectful to the jury, first of all. And second of all, the deputies have been directed to take out individuals that may pose a problem. And that doesn't matter which way the verdict is. So we'll see what happens. The jury's ready, bring them in. All right, ladies and gentlemen, it's my understanding you've reached a verdict, is that correct?
Yes, Your Honor.
And you reduced it to the verdict form you believe correctly?
Yes, sir.
You can give that to the bailiff and everyone may be seated. Mr. Kendhammer, if you'd please rise for the reading of the verdict. State of Wisconsin versus Todd A. Kendhammer, 16 CF 909. We, the jury, find the defendant, Todd A. Kendhammer, guilty of first-degree intentional homicide as charged in the information. Dated this 14th day of December, 2017. Signed, Timothy, foreperson. You may be seated. Ladies and gentlemen, the verdict I just read, if this is the verdict of each of you, would you please raise your right hand? I see all 12 jurors have raised their right hand. Thank you. Mr. Grinke, do you wish the jury polled?
No.
Mr. Hurley?
Yes.
All right, ladies and gentlemen, at this point I will ask each of you individually by pointing at you what your verdict was, and then you can put that on the record. We'll start with you, Timothy.
Guilty.
You? All right, all 12 jurors have responded guilty. Anything further from the defense? Ladies and gentlemen, at this time, your service to the county is completed. There's several things I need to talk to you about. Once you are in the jury room, I'll be there momentarily. You are now discharged. There's no further requirement of secrecy. You may talk to anyone you wish about this case, and you don't have to talk to anybody at all if you do not want to. And I'll see you in a few minutes. The record could show we're now outside the presence of the jury. Mr. Grinke, any further comments?
No, Your Honor, we're going to ask that his bond be revoked pending sentencing.
Mr. Hurley, anything further?
Not at this time.
Okay. Well, the court, having heard the testimony, will accept the jury's verdict. I'll enter a judgment of conviction on behalf of Mr. Kendhammer on count 1, first-degree intentional homicide, contrary to Wisconsin statute, section 940.01, parent 1, parent A, and 939.50, parent 3, parent A. I will revoke your bond. You'll be remanded to the custody of the sheriff. I'll set sentencing for March 9th, starting at 9 o'clock. I'll ask that any PSI be submitted to the court no later than the 1st of March. We're adjourned.
How do you keep your head up? All right, Dad, we'll get you out. Don't worry about it.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. Well, there you had it. There's the verdict in the Todd Kendhammer case. After 9 hours of deliberation, 10 women, 2 men, they found this man guilty of first-degree intentional homicide. You saw the reactions, the utter surprise, the shock on his face and his family members when that verdict was read out loud. His $250,000 bond has been revoked, and sentencing will be on March 9th. He could face life in prison. I'm here with criminal defense attorney Jayne Weintraub talking about the Kendhammer case. Jayne, you saw that reaction. You saw what happened. I think the family was shocked, to say the least.
I think so too. I think he was genuinely surprised. Even the lawyers. I think that they really did not believe if it came back at all, it would not come back as a first-degree murder. That's what I thought also. I did not think it would come back as a first. I thought, if it's anything, it's going to come back as a second, as a moment of rage. You know, the definition of second-degree murder would be a depraved mind, no planning, and that it was a spur-of-the-moment killing. I think that the jury wrestled with the instructions of the court.
You know what it is? We here on the Law and Crime Network, we cover so many cases where we see hung juries. I was expecting a continuation of that. I thought we might see that here because it was difficult. I mean, I debated it with different hosts, different guests, different people, and people were split. I have to tell you, in the cases we've had, people were split. There were people who thought he didn't do it. There were people who said, I'm not sure. But the majority of people said, if I was on the jury, I'd have to say there was reasonable doubt. So it is a surprise, but the jury, they found him guilty. And Jayne, I am curious about one thing. Do you think it was also the number of injuries that were not perhaps consistent with that pipe that did it for them as well? The fact that she had so many injuries.
I'm sorry, I didn't mean to step on you.
No, no worries.
No, because I think it was a matter of the medical examiner. And I thought about, while I was watching the display of emotions, I thought about what you'd asked me earlier. The only thing, and maybe the defense did it, we'll never know, whether or not they consulted with an independent medical examiner. Because I just don't accept the medical examiner's opinion so readily as everybody else does. And I think that those opinions need to be challenged on a more regular basis.
Well, they did bring in their own experts who said that all of her injuries are entirely consistent with an accident, and that pipe could have came through the windshield and she could have ducked and it would have hit her in the back of the head and there was glass, and they tried to explain the fact that if you look at the glass right there, the glass impact in the windshield,
right,
there were 3 impacts, as one of the experts had said. That was from Todd punching the glass, the pipe coming through the windshield, and also trying to remove the pipe. They said it was entirely consistent.
Not everything goes as science dictates. I mean, it's not, when you just even moved your fist, some of the glass might have splattered somewhere else. I mean, that's what's not accounted for. For me, this case was filled with reasonable doubt on the injuries, on the motive, on the intent, on the lack of evidence of first-degree murder. And he's guilty of being a liar, but that does not make him guilty of first-degree murder. And
But
unfortunately, the appeal of sufficiency of evidence, I don't think will fly.
well, it's interesting because I think the prosecution did a very strong job of pointing out the fact that this man was being inconsistent, he was not being truthful, and he was not being forthcoming about what actually happened to Barbara Kendhammer. So what I would like to do right now is I'm going to play for you some of the prosecution's closing argument. Again, I thought the prosecution and the defense delivered very strong closing arguments, and I'm going to play for you some of the prosecution's closing argument for you. We'll continue it later on as well. And when you come back, we actually have a special segment with Jayne. It's about Uber. Uber. How many people use Uber? Well, I hate to say it, Uber is facing some serious trouble right now. There is a criminal probe that is going to be launched against Uber. We'll talk about it when we come back. But in the meantime, here is here is the closing argument by the prosecution in the Todd Kendhammer case.
Be seated. Okay, ladies and gentlemen, yesterday I gave you the